all of you honorable members, all of us on the virtual platform today, to welcome the members, the media with us, our entire support staff, members of the public who are joining this committee meeting in their various platforms. I just want to indicate upfront that this committee meeting is specifically convened to fully prepare for the resumption and the conclusion of the inquiry. As such, the focus of our discussions today will be mainly on two areas. One, to get an update on the legal support appointment process. You would remember that our last meeting we had on the 17th was about ensuring that that's in place. Secondly, we're going to have to adopt the revised program, and all of that will have to be executed within the timelines, the limited available resources, which means it's the budget and the time that we have. We're still operating within those 22 days in which we need to conclude our work. There are no extra days. There's no extra money. Everything else will have to be done within those limited resources, both time and money. Our process has always been guided by two important principles. One being our task to complete our work within a reasonable period or time frame as per our rules. And all of you would know that we have been challenged in that regard. We should have long concluded this process, but we have been patient. And we also do that to work diligently, of course, without delay, per the prescripts of our constitution. But the second principle has always been and continues to be that of acting fairly throughout this process. These are the two guiding principles that are guiding our work. But more importantly, as we meet today and resume, as we plan the resumption of our work and when we will conclude, I want members to be very mindful that any further delay of this process or even postponement will not be in the interest of the public, is not in the interest of the institution that will come from the National Assembly, will also not be in the interest of the public protector, who is the subject of this inquiry, who accounts to the National Assembly. It's therefore going to be important that as we engage in our discussion today to prepare for the resumption of our work from next week, we are very much mindful of the fact that we don't have infinite time. We cannot continue with elastic deadlines, and that we need to remain focused to conclude our work without affecting anybody's rights. But as I've indicated, the work that we do must be in the best interest of the public protector and this process itself. We've got to balance that. We will not continue to just act as if the only interest that we must be guarded here is one over the other. That's going to be very important. That having been said, I'm going to ask the Secretary to indicate if I've got any apologies. Thereafter, I'm going to ask our legal advisor, Ms. Fatima Ibrahim, to take us through on the update you would have received a lot of correspondence. To summarize what we have received as part of the update on the appointment of the legal support. And following that, Mr. Ngoma will also table the revised program that you would have received a draft of. Thank you, Mr. Ngoma. Those are the two apologies that we have received of Honorable Gond and Honorable Heron. Thank you for that. We proceed. Ms. Fatima Ibrahim, if you're on the platform, I now want to invite you to take the committee through the update on the process. And I'm going to urge you not to, even though members would have received the correspondence, but to ensure that you take members through all the critical steps that we would have been engaged on. And before you come in, I do want to appreciate the role of the PPSA, the Public Protector South Africa, as well as the State Attorney's Office, the Solicitor General, for their work to ensure that that which you'll present now, they've done work in that regard. Over to you, Ms. Ibrahim.
Thank you, Chair. Good morning to yourself, all the members and the staff on the platform. Chair, if you'll allow me, I just want to do firstly a very quick update in terms of the litigation, just so that members are aware. Members will recall that the PP took the issue of the non-recusal of yourself and Honourable Milam on a review together with a few other matters, and that judgment was handed down on 13th of April. And in terms of that judgment, the full bench of the High Court had ruled that the PP had brought the matter prematurely, so in the middle of proceedings, as it were, and they then did not proceed to deal with the merits of the issue. The Public Protector launched an application for leave to appeal that judgment. That application was heard earlier this week and judgment was handed down yesterday. The Public Protector has been granted that leave to appeal now to the Supreme Court of Appeal. So the matter will proceed there. There was also, Chair, a conditional cross appeal, and the cross appeal was a cross appeal launched by yourself just in relation to the cost issue. So in the main judgment of the High Court, they had ordered costs against the Public Protector, but not in her personal capacity. And the issue that's now been raised in the cross appeal, which has been granted, is that the Public Protector, given her suspension, cannot act with authority for purposes of the PPSA Act. So she couldn't have launched those proceedings. So it is a technical issue, but I have asked the Secretariat to please share the judgment with members. It is a very short judgment, and we of course will keep members updated as to what happens in the ECA. The appeal does not have the effect of an interdict. So in law, there's nothing that prevents the committee from continuing. But of course, as I always advise, that's for the committee to decide how they would want to manage that. But that is a parallel litigation process that's ongoing. Chair, when the committee last met on the 17th of May, you will recall that the PP confirmed that CNEGO attorneys are no longer acting as her attorneys of record in the matter, and she requested our assistance via the PPSA in procuring Chan attorneys, and that is a law firm that is on the panel of attorneys that the PPSA uses when procuring outside legal services. The reasons for CNEGO no longer participating in the process or being on brief are still not apparent. Members will recall that they raised the issue of professional legal privilege, and the PP didn't waive that. So we abandoned that investigation as to what the cause was, and we then proceeded to try and assist the PP via the PPSA to secure the services of Chan attorneys. On that same day, Chair, the 17th of May, members will also recall that we tabled a letter from the Solicitor General where he set out various ways in which the funding and the appointment issues of new attorneys could be resolved, because the PPSA had made contact with the Solicitor General on these matters, and he had recommended that the PPSA should explore alternative options to mitigate the financial burden, and included in that would be renegotiating fees for the current legal team, possibly streamlining the legal teams, in other words, reducing the number of the legal team, introducing other cost-saving measures, and so on, and at all times, though, ensuring that the process remains fair. They then also offered the PPSA that they would assist, if the PPSA required such assistance, to outsource the attorneys, being Chan attorneys, so that there's some arm's length between the PPSA and Chan attorneys. And in fact, that negotiation then happened. We wrote to the PPSA chair on the 18th of May, and we asked them to please assist the public protector, because of the request that she made to the committee the day before, to now instruct the new attorneys, because Sianejo had indicated that for professional reasons they were no longer involved. On the 23rd of May, Chair, we received correspondence from the CEO of the PPSA, and she confirmed that they had liaised with the Solicitor General to facilitate the outsourcing of instructions for the further legal representation of the PP to Chan attorneys, with the retention of the PP's preferred counsel. Because members will recall in the meeting, she had indicated that notwithstanding that Sianejo is no longer participating in the process, Advocate Mpofu remains her counsel of choice. At this point, Chair, it's our understanding that there was then a negotiation between Chan and the state attorneys on the conditions of appointment, as their role was specifically sought in order to manage these negotiations, given the Solicitor General concern about cost containment. So that is why that office was originally asked to assist. On 23rd of May as well, Chair, the State Attorney confirmed that Mr. Chani has been appointed as the Attorney of Record, or correspondent attorneys, as they put it. Members may be aware that in order to brief counsel, you need attorneys to act as the conduit to do that. And Mr. Chani was advised that he could now deal directly with the public protector herself, and wouldn't deal with the office of the PPSA. His appointment was conditional on briefing only Advocate Mpofu, and that at a rate of 45,000 per day. So it was our understanding at this point, Chair, that the negotiations with Chan attorneys had resulted in them arriving at this settled amount of 45,000 per day, and the use of Advocate Mpofu. The PPSA, as you know, had committed to covering the reasonable and budgeted costs associated with the representation of Advocate Mkhwebane, including the legal fees and disbursements, but to a maximum of the 4 million, which was the amount, the additional amount that had been made available. On 24th of May, Chan attorneys wrote to the PPSA, and they informed them that after having contacted Advocate Mpofu, he indicated that he would now only accept the brief if the status quo remained, and if his two juniors were brought back on board, and that would have been Advocate Shabalala and Advocate Matlape, who the committee is obviously very familiar with, who have been part of the process since we began. On 25th of May, Chair, there's a letter from Chan attorneys where they indicated that the issue of counsel's availability was still in discussion. And on the same day, they were then informed that subsequent to engagements between the Solicitor General and the PPSA's office, that there was now agreement that they may proceed on briefing all three counsels. So in other words, the original team would now be retained. On that same day, then, Chair, myself and the Secretariat met with Mr. Chani. The purpose was an onboarding exercise, if I could put it that way, just to familiarize them with the work of the committee, introduce them to the way in which the committee manages its electronic record, and so on. And at the same time, they were also making arrangements with Sianejo attorneys to get the balance of documents that those attorneys had in their possession. On the 26th of May, Chair, we confirmed with them that we've now granted them access to the Dropbox. We also shared with them the latest transcripts of the evidence leaders' presentations that had happened after the 31st of March. And they confirmed the following day that they do have confirmation of the access to the Dropbox. And then what we also did, Chair, was to provide them with an explanatory note on how to navigate the Dropbox. So for the benefit of members, the Dropbox is the equivalent of Parliament's Uvimba. It's our electronic database where the evidence leaders and the PP's legal team have been uploading all documents. In turn, the Secretariat shares those documents with the committee. And the reason for taking them through it and doing the explanatory note is that there is this figure, I think, of 63,000 pages that has been floating around to say that the record is that large. But of course, the way in which we've divided that Dropbox into various sections means that there is quite a bit of duplication. So if I just give a quick example, the first part of the Dropbox, section A, contains the panel report and everything that the panel had done, and that was before the panel in terms of the evidence submitted in support of the motion. So those judgments in support of the motion would appear in other parts of the Dropbox where we have sections dealing with judgments and so on. So that was the purpose, just to assist Child attorneys to be able to navigate that. And they confirmed that they then had access. Chair, between the 29th and 30th of May, there's various emails between the Secretariat and Chani attorneys to try and figure out whether counsel has now come on board and what the delay is, especially given that, as far as we knew at this point, the request that Advocate Mpofu had that he be allowed to continue with his juniors had been acceded to. And we were then told on 29th of May that the PPSA had been advised by Chan attorneys that counsel has now submitted a new fee structure. And in terms of that new fee structure, Chair, the rate for Advocate Mpofu had increased from 45,000 per day to 51,000 per day. For Advocate Shabalala, from 27,000 to 30,000 per day. And then for Advocate Matlapi, from 18,000 to 21,000 per day. And the PPSA then responded to the State Attorney with their concerns that this would amount to an additional 12,000 per day than what they had originally understood. And that there's only this ring-fenced amount of 4 million, which Advocate Mkhwebane would have to manage. And they also then raised an issue, Chair, that despite Advocate Mkhwebane having been on record that the legal team is assisting her to reduce the rate, counsel fees have now increased from 90,000 to 102,000 per day, and that the information at their disposal is that these fees are at the upper end of the average or normal rate of counsel in the various centres. On 1 June, Chair, we received an email from Chan attorneys where they indicated they're still waiting on the State Attorney to get back to them on whether they may proceed to appoint counsel based on these new rates that had now been proposed. And we received correspondence, Chair, very late last night from the CEO of the PPSA indicating that yesterday during the course of the day, the State Attorney had in turn sought further clarity from her office on the acceptance of the proposed fee structures. And they confirmed acceptance provided that it would be on a record that only the amount of 4 million is available and that anything that may be required beyond that 4 million would be for the account of the PP. So that's the communication now between PPSA and State Attorney, because PPSA, of course, would still be paying for these fees via the Office of the State Attorney. The PPSA then informed us that as far as they're concerned, the issue of fees has now been sorted and there's no impediment in us continuing with the matter. This morning, Chair, we received an email from the PPSA attaching an email from the state attorney to Chinese attorneys, in which the state attorney indicates that on instructions of their client and in the interest of time and progress in the proceedings, that the client has agreed to counsel's fees as stipulated in the letter. So that would be the increased fees that I read out earlier, and that the instructions are to advise that the funds are limited, and that once the allocated funds are exhausted, that the PP would then have to carry the costs of any additional funds out of their own pocket. Of course, Chair, we do now sit with the issue that there is only the 4 million as far as PPSA is concerned, and with the increase in rates on the one hand, and the fact that all three council are now back on board, it does mean that there may possibly, or definitely at least, will be less days available in which to manage those funds. So unfortunately, whilst it appeared that in the beginning the purpose of engaging with the SG would be for cost containment, the effect of what we sit with today is that costs wouldn't contain. It seemed to have gone up, but that is where we stand currently, Chair. So I see that Tim Nkosi is on the ball this morning. He's already sent a WhatsApp on our backroom chat group, asking for an urgent backroom meeting with council so that we can just plan the way forward and do the usual housekeeping things that we do in the background, Chair. Thank you.